Okay, welcome everyone.
And so Dobbs' impact on other privacy rights is something that we are, concerned about. Although the majority promises that this decision is limited to abortion and won't affect other 14th Amendment rights, its reasoning still threatens these other substantive due process rights. And Clarence Thomas, in his concurrence, wrote, in future cases, we should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell, because any substantive due process decision is demonstrably erroneous. We have a duty to correct the error established in those precedents. So while that is just a concurrence, that is a pretty concerning call that welcomes eroding these other rights. So Griswold v. Connecticut, that is another case that could impact, it was not overruled, but access to contraception, interracial marriage, which was ruled constitutional in Loving, Virginia, same-sex relationships, Lawrence v. Texas, same-sex marriage in Obergefell. So all of these cases followed the substantive due process rights. And so this is what we are concerned about, possible implications of Roe being overturned. So the nationwide impact is very profound. It will force millions of people to carry an unwanted pregnancy to term, force them to travel hundreds of miles at a great expense to themselves, childcare issues, not being able to get off of work because folks will have to travel to states where abortion is legal. The maternal mortality rate in the US is already very high compared to other countries, and this will only make that worse. And the maternal mortality rate is especially disproportionately high for Black women. This will also increase the criminalization of pregnant people in general and create suspicion of and danger for people who are experiencing miscarriages. So here is just a graphic of the US, the kind of what the makeup looks like right now. So folks can just take a look at that.
Notably, probably since we pulled this yesterday, Kansas has moved from legal for now to just legal. So
yes, that
hooray
is
for Kansas.
Whereas Indiana might move from legal for now to banned any day now.
Yeah.
Yes.
So we put the date on here because I wouldn't go around showing this off in a week. It might be a completely different map.
Right. Yes. If you want to go to the next one. I can't really see.
This is the restrictions map.
Okay. And that one's current as of?
That was from yesterday.
From yesterday, okay. So yeah, as you said, it's constantly changing. So these maps very well could change in a matter of days.
This map reflects kind of, even where there aren't outright bans in place, where there's still a lot of restrictions on abortions, including waiting periods, including restrictions on providers, all these issues that aren't outright bans, but still create a lot of problems for access.
Yep. And so some of these restrictions that create barriers to access include physician requirements. So 32 states, as of right now, I believe, so 32 states have physician.
But that includes states that have banned abortion entirely.
Yeah. So, so this means that other clinicians, other like advanced nurse practitioner, folks who are qualified to perform abortions, they are restricted from doing so because of the physician requirement, which of course limits the scope and the number of folks who can actually provide this care. TRAP laws, which TRAP stands for Targeted Regulation of Abortion Providers. these trap laws impose onerous licensing standards under the guise of it being for, medical purposes and the health of safety of the pregnant people, when it really is just to create more barriers. State mandated counseling, which requires that the state provide before a pregnant person accesses abortion, that they receive counseling and are often given information that is factually incorrect, such as breast cancer links and other issues that have been that are not medically sound. There's also waiting periods, another just obstacle for folks to extend, the amount of time that they have to wait. And this is problematic because of requiring multiple trips, especially if you are traveling to another state. And then parental involvement laws, they require some kind of parental notification if you are a minor trying to access abortion. And in a minute, Emily Hirsch will talk about the Parental Notice of Abortion Act in Illinois, which was thankfully repealed, and that was a huge victory. So in Illinois, we no longer have that dangerous law. So we'll turn it over to you.
Yeah, so that was a pretty bleak picture, but as you may have noticed, Illinois was like one of those little blue islands in the middle of a sea of restrictions. But, just want to ground us in the reality of what that means. So in Illinois, we've kind of been preparing for this moment for many years at this point, starting with HB 40 in 2017, which removed Illinois' trigger language and other provisions like a spousal consent law for somebody to access an abortion. These weren't being enforced, but they were on the books. It also essentially extended Medicaid coverage for abortion to people in Illinois, which was a huge, huge milestone for access for lower income people. In 2019, we passed the Reproductive Health Act, which codified the fundamental right to abortion in Illinois. It extended insurance to private insurers with a few exceptions. And it focuses on evidence-based standards and removed some other old laws. So when we say evidence-based standards, we mean things like allowing people other than only physicians to provide this kind of care. Finally, and very excitingly for the three of us and other folks, PNA was repealed in 2021. PNA was the Parental Notice of Abortion Act, which required minors to notify a parent if they were going to access abortion. If they didn't want to do that, or if it wasn't safe for them to do that, they had to go in front of a judge and have a hearing and basically prove to the judge that they were mature enough to get an abortion. So obviously that makes no sense, and we're extremely excited that that is no longer on the books, especially because of what I'm about to talk about. Oh no, after this. But in Illinois, outside of the abortion context, we also have pretty good contraception policies. Illinois law requires insurance companies to provide coverage of abortion, including 12 months of hormonal contraception. Emergency contraception, this is Plan B or Ella, I think is the other one. Is that right?
There's multiple ones.
There's a bunch. Are available over the counter. And Illinois law also now allows pharmacists to prescribe and dispense birth control, so you don't have to go to a doctor. So just because Dobbs did not take or cause abortion restrictions in Illinois to go into effect doesn't mean that we are not feeling those effects here. We've had a huge influx of patients from neighboring states, and we were already providing a lot of care for people coming from out of state, especially from Missouri. So it's been speculated that the number of additional patients traveling to Illinois could increase by 20 to 30,000 just this year. And I was listening to somebody at the Chicago Abortion Fund talk yesterday who said that the amount of money that they are having to spend in a week has increased like by a huge magnitude. So the need in Illinois has just skyrocketed immediately. Outside of that, a lot of these hostile states to abortion are trying to pass these laws that say that they apply to people who travel outside of their state. So that could expose people in Illinois, providers, people who are facilitating this kind of access to liability. This is a big question that I think Emily's going to talk a little bit more about, but it is kind of a looming threat to providers and folks in Illinois. So just to kind of give another example of an area where we in Illinois have more work to do, even though we do have pretty protective laws, is reproductive healthcare access for people who are incarcerated in this state. So just for some context, women are the fastest growing incarcerated population nationwide. As you can see, there's been a truly ridiculous increase between the 80s and a few years ago in Illinois. And this is a big issue because prisons are built for cisgender men, and they, arguably they aren't built for anyone, but they certainly are not able to accommodate anybody else other than just cisgender men. So we do have some protections in Illinois. This includes the Reproductive Health Act explicitly applies to people who are incarcerated. So there is an Illinois law on the books saying that incarcerated people have a right to reproductive autonomy and to make decisions about their own healthcare when it comes to their reproductive healthcare. And there are some state statute provisions on shackling and restraints during labor. You might think that that's not something that you would have to specifically say, but we did. There also last year as part of the Safety Act were passed some additional requirements like training requirements for prison and jail staff about pregnancy and about why you shouldn't restrain pregnant people, and requirements that they should not be put into solitary confinement and that they should only be given beds that are 3 feet off the floor or lower, again, for reasons that I would think are pretty obvious, but we still have a lot of issues in this space. There's those laws about shackling on the books, but a lot of the time they're not being complied with and people are still being restrained during labor or on their way to or from giving birth. There's also widespread forced or coerced induction of labor for people who are pregnant while they're incarcerated. Where basically, if you're pregnant and you say, I want to deliver, I want to go into labor, when my body decides I want to go into labor, they say no. It's a liability hazard for us. Like, we basically won't help you. So that's an absolute outright violation of the Reproductive Health Act. It's a constitutional violation. It's not acceptable. People are also not getting adequate prenatal care. They're being told that when they complain about it, they're being told that if they wanted to have prenatal care, they shouldn't have gone to prison. Access to abortion is an issue because the law does not require facilities to pay for people's abortions if they're incarcerated. They basically can't prevent them from getting one, but they don't have to pay for it. Also, people who are in, kind of smaller county jails who want to access abortion have a lot of issues with privacy around that, because if there's only, 4 or 5 guards and they might be people it's going to be a big problem for you. They're the people who are going to need to be taking you to the clinic, and they can really make your life hard if they decide to. So that's a really big problem. Contact visits are becoming a thing of the past in a lot of these county jails and in some IDOC facilities. This is a huge problem for families, anybody who has kids. Most people who are incarcerated who are women are moms, they have kids. And if they're just like not being able to see their kids at any time, that's a reproductive justice issue. And this is kind of across healthcare facilities, in prison facilities and jails. Access to healthcare is extremely limited and is 100% what's the word I'm looking for? The gatekeepers for all medical care is these prison staff who just decide whether or not they want to believe you. So all that to say, Illinois is a protective state, but that doesn't mean that we as lawyers, as people in the state, don't still have a lot of work to do.
So I'm going to talk about some other sort of emerging areas, issues that we are thinking about in this post-Dobbs world that we're in, where we don't actually really know the answers or how things are necessarily going to play out over the next 5 to 10 years. A big one is the question of what supportive states like Illinois can do to protect abortion providers and funds and people who provide practical support like rides and a place to stay in their states. And as Davina or Emily mentioned, I can't remember whose part it was, that we are hearing of a lot of interest in these hostile states that are banning abortion and also extending the reach of their bans outside the borders of their states and trying to prevent residents of their states from traveling to other states and accessing care by, criminalizing the doctors, the people who provide support, or making them civilly liable. There are a lot of ideas floating around for what we can try to do here in Illinois to protect those folks, but a lot of them are really untested and based on areas of constitutional law that are extremely esoteric and not well developed, like the right to travel, the dormant commerce clause, like things we never thought were relevant to abortion rights. And then the other new area of constitutional law that we're having to become experts in is the full faith and credit clause, which requires one state to give full faith and credit to judgments from another state. A lot of the ideas that are being floated around are like, oh, well, we just won't let our state courts enforce a judgment, or we won't let our state courts cooperate in a criminal proceeding or a legal proceeding based on another state's law. But there are limits because of the full faith and credit clause on how much one state can say, we're just going to ignore the law of another state. It's not absolute. There is like a lot of play in the joints there, but it's pretty clear that, for example, Illinois can't say, if someone sues you in Missouri and gets a judgment against you in Missouri that's lawful under Missouri law, and then they try to come here and enforce it in Illinois, we're just going to say no. So there's a lot of people doing research in all of these really new, well, old, but new to us, obscure areas of law to try to figure out like what is the most protection that can be put into place for the people who practice and provide and support care here against the kinds of hostile actions that folks from other states might take against them. And it's just very, like, there's a lot of news articles about, oh, they should refuse to comply with subpoenas, they should refuse to do extraditions. These are all interesting ideas, but whether they're gonna like stick or whether if someone challenges them, the Supreme Court might say no, and you can't refuse to extradite someone. We just don't know where like this is all going to land at the end of the day. So that's an interesting sort of emerging area in the realm of reproductive rights. And another one that is long-standing but takes on new importance in this post-Dobbs world is what states can do about the impact of religious refusals on access to reproductive health care. So a large number of hospitals and other healthcare providers are owned or affiliated with the Catholic Church or with other religious organizations that limit the kinds of care that can be provided. And they don't allow things like abortion, some contraception, sterilization, gender affirming care, end of life care, those kinds of things. And so regardless of whether it's legal under state law, it's not allowed within that hospital system, and anyone who's affiliated with that hospital system is not allowed to provide it. And there are legal protections for them. So there's, obviously the Constitution and freedom of religion. Also in Illinois, we have a law called the Healthcare Right of Conscience Act, which explicitly says that if you have a religious objection to providing healthcare, you don't have to provide that care, and you can't be held liable if you refuse to provide that care. So even if care is ostensibly available in a state, if you live in the part of the state where healthcare is dominated by one Catholic institution, that care is still not necessarily accessible to you in your community. And Illinois and a lot of the other supportive states are trying to figure out how to address that issue, while at the same time knowing that those organizations, the religious healthcare organizations, also have their own constitutional rights in terms of free exercise, et cetera. And so finding the balance there is another emerging area, made especially interesting, I think, by the fact that the Supreme Court has been moving really aggressively in favor of Christian people's free exercise rights. So we just had the case from this term where the court said that a school couldn't punish a football coach who was praying at the end of games, even though some people in the community felt that it was pressuring students to participate in the prayers. And the Supreme Court upheld the religious freedom rights of the coach to do that. So we know, at least in the federal courts, there's a lot of support for religious freedom of the people who claim they want, a religious exemption or based on religious grounds not to do something they would otherwise need to do under state law. And there's a lot of support for that. So even as we're thinking of ways to try to blunt the impact of religious refusals, we also have to see what kind of support those people's own rights that they might claim are going to end up having. So some of the ideas that are being floated around are things like requiring hospitals to put on their website very clearly all the services they don't provide. One of the things that we tried to do in Illinois is pass some amendments to the Healthcare Right of Conscience Act, which say, if you're not going to provide the care, you have to at least say, this is a legal healthcare option, and these are the potential risks or benefits of pursuing that. And here's where you can find more information about that, but we don't provide it here. But that has been enjoined with regard to abortion care in the state because of a lawsuit brought by crisis pregnancy centers. So organizations that are set up to try to dissuade people from accessing abortion have argued that they don't want to have to say that abortion is a legal treatment option with benefits, and there's a federal court injunction against those amendments to the Healthcare Right of Conscience Act at the moment in that case. So that's another area where there's sort of new impetus, but also conflicts of rights, and we're not sure where it's all going to land. So just in terms of some things that you can be doing, especially if you're in Illinois right now, the Chicago Abortion Fund and Midwest Access Coalition are two support funds for abortion that are doing absolutely critical work. They're seeing huge influx in their numbers of people who need their help because so many more people are coming to Illinois. So you can always, support with your money. We know a lot of folks are interested in donating their time, but actually these organizations are so underwater with just responding to all the requests for help that they're getting. They don't really have time to take advantage of volunteers just yet, but they can use your money. So if you're so inclined, that's something that you can do. And then it's really important to stay politically engaged. Even in a protective state like Illinois, our protections are only as good as having a General Assembly and a governor and a state court system that believe in those and are going to uphold those and keep those on the books. So we need to make sure that people who care about this issue continue to see choice as an important voting issue for them in every election. So definitely important to stay engaged, to know, where candidates stand if this is an issue that's important to you. And one thing that you can do to know more about opportunities to get engaged on these issues in Illinois is to sign up for the ACLU of Illinois Action Alerts. So as the Illinois legislature tries to do more things that might protect providers here in Illinois, and if we think those are good ideas, we send action alerts saying, hey, call your legislator, and you can be aware of it in that way. So I think we can open it up to questions.
We did have one question that was already asked about the period tracking apps.
Oh, yeah, that's right. That's another we don't know area. So there's been a lot of news coverage about the possibility that governments could get access to the data that are in these period tracking apps and then basically use it to target people who have missed their period and investigate them and see if they were pregnant and what happened with their pregnancy. Especially because those companies are private companies and the Constitution doesn't apply to them in the same way. It's hard to know if there's anything we can really do to stop the companies from selling that data to the government if they want to. So it may become more an issue of public pressure. I know there are some attempts at the federal level to look at this issue and try to think about what can be done to limit by new federal laws the selling of this data, but those have not been passed yet. For folks who are concerned, I think the only true solution is to delete the app, but that's another emerging issue where I think we have to wait and see what Congress may or may not decide to do, what these companies may or may not decide to do in pursuit of profit, what the government may or may not decide to do if it can get access to that data.
Yeah, with those, there's also the danger because they just, they have this information and we also have these Texas SB8 style civil enforcement mechanisms floating around that they could get subpoenaed for information that's being kept in there. So even if it wouldn't then expose somebody to criminal liability, it could expose them to this bounty hunter scheme that is going on in several states. So all that to say, it is probably concerning, but we're not quite sure exactly how much. Any other questions?
I know you talked a little bit about the due process in the beginning, but there was a question about that, about how did the test for due process change? What the level of scrutiny is, and how it applies to these cases. Do you want to go into that specifically a little bit more?
Sure. So the Roe v. Wade established that because abortion is a fundamental right, that it should be, any regulations should be viewed under the standard of strict scrutiny, which is the highest form of scrutiny in constitutional challenges. So that means that it has to be narrowly tailored and to promote like a state's valid interest. And so Casey took out that the strict scrutiny standard and instead replaced it with an undue burden test. And so that removed a layer of protection from Roe v. Wade because it lowered the standard that regulations could be reviewed under. And what was the other part of the question?
So what's the standard now after Dobbs?
Rational basis, right?
Yes.
Yeah, it's rational basis review for abortion restrictions.
Which is the lowest.
Right, and everyone knows it's pretty easy for a government to overcome a rational basis standard.
And as Davina noted, Alito's opinion also just like served up a bunch of example rational interests for the government to have in creating an abortion ban. It's just like you could pick this or this or this or this.
Right,
So
including protecting the potentiality of life, which
also like preserving
therefore justify a ban as early as immediately
right,
upon
yeah,
pregnancy.
all kinds of kind of weird nonsense as well.
And so just a little bit more about that, the something that was very critical in Dobbs was the fact that they ruled that because abortion is not explicitly referenced in the Constitution, it is not a fundamental right. And obviously there are a lot of rights that were not contemplated by the founders. And so this is problematic for, emerging issues that we, as we progress as a society, that we hold different views and we expand access for folks who were not even considered when the country was founded. And so by this new standard of having to be deeply rooted in the history of tradition in order to be a fundamental right and therefore warrant strict scrutiny, it's a lot more challenging now to establish that something is a fundamental right if it is not, if it does not meet that standard. And that's why we worry about the impact that would have on other cases that view that before Roe was overturned, the substantive due process was viewed to have a right of privacy. And so because of that, cases like Griswold about contraception, interracial marriage, all of those, the reasoning was from earlier precedents. So even though the opinion, like I mentioned before, said that this does not open, that this concerns only abortion, Justice Thomas, welcomed the reviewing all of those cases that relied on the substantive due process, right, of privacy. And the makeup of the Supreme Court, I think it's fair to say that they would welcome, trying to challenge all of those rights that we, really consider so deeply fundamental. Did that answer the full question? Okay.
Any questions on that one?
I guess how likely do you think it is that they'll go after those rights that you just talked about? And I guess that's my question. And if so, when?
Yeah, that's a great question, but a the answer is we don't know. We just don't know.
Yeah, I mean, this is just me speculating and not representing the position of the organization, but I think it's really likely that they're gonna go after contraception.
Really, I was gonna say the opposite.
So here you go, we have two Emilys in opposition. But I think it's pretty likely. I think that there's, because you don't have to have necessarily, yeah, and it's not a matter of like popular opinion, right? Because I don't think that there's a majority of people in this country who want contraceptive access to be limited, but there's not a majority of people in this country who want abortion to be limited to the degree that it is now either. So I think that all you need is like a state to do a statute, and then that to get brought all the way up to the Supreme Court, where I think it's been shown that there is ample appetite to take that out of the realm of fundamental rights.
I was gonna say the opposite, because I just think that folks will deem it politically unwise. Not because there isn't some appetite to do it, but that cooler heads will prevail and say, contraceptive rights are more popular than abortion rights. They're both supported by a majority, but contraception rights are supported by like 90% of people or something like that. I think if anything, they might go after certain types of contraception, like emergency contraception or IUDs that are more controversial. But I mean, again, we saw with this situation in Kansas yesterday, where the attempt to overturn their state constitutional protections for abortion was voted down by a huge margin, more than people anticipated. I think politically speaking, people don't have a huge appetite to make this a fight about contraception because it's not a winner politically. But again, two different theories on whether people are rational, where people see their interests lying in terms. I think there is certainly a route to them. Whether they're going to decide to take it up is a different question.
I mean, I hope you're right and that I'm wrong.
Who knows?
What are your thoughts on the Kansas ballot and that kind of like strategy that goes to like changing the Constitution, and it kind of like backfired yesterday for the advocates of that. But I think that's a scary strategy for the other side, for us, when we're thinking about like putting that on the ballot.
It's going to be tested soon. It's going to be on the ballot in Michigan probably, and I think Vermont this fall. So I think we'll see if people will support it. I mean, the situation in Kansas was the opposite, right? Their constitution has already been interpreted to have a right to abortion, and so that was the anti-choice folks trying to reverse that interpretation so that the legislature could do whatever it wanted, including ban abortion, and folks said no. There are ballot initiatives coming up, maybe this fall, maybe next year, I can't remember, that are to explicitly recognize a right to abortion in a state constitution. And we'll see if they win. I mean, I'm feeling really hopeful after yesterday, but maybe I'm being too ambitious. I don't know.
Yeah, we were just talking about this actually before we started up, because it really does show that in Kansas specifically, and hopefully in other places, because you don't think of Kansas as being this kind of like access hub where everybody's really supportive, but it really goes to show you that a majority of people, even if they don't believe that everyone should have an abortion all the time, they don't think that it should be outright banned either. So if that's the question that people are putting up, which is largely the question that's kind of being presented, I think that it is, and again, I might be over optimistic here, but I think that it's more likely to go in the access route than the outright ban route. I think that people's actual opinions on this lean more in that direction.
And going off that, this is why, you know, voting is such a critical issue, and all of the, you know, issues with voter restriction laws that are created just to create a barrier for folks to be able to access the polls, whether it's, you know, not allowing early voting or not having huge lines and criminalizing people who provide water or food to folks. Like, it is so outrageously clear that they just want to make it harder for the people to vote. And so that's why, you know, voting issues are, and voting access, expanding that is so critical, especially right now. Always is, but especially right now.
So we do have another question in the chat. Rachel is gonna unmute and ask her question.
Hi, thank you so much for the talk. You might have answered this in your last answer, but just with federal precedent now so critical of substantive due process, what do you think the role of strategic litigation is right now, or should be in regards to these issues? Is it about state constitutions? Is it about making sure voting rights are being respected?
That's a really good question.
Yes and yes. I mean, certainly when it comes to abortion, the focus is entirely shifted to state constitutions pretty much. And there is ongoing litigation in a bunch of states trying to establish state constitutional protections for abortion now that Roe has been overturned. In terms of some of these other areas where it's like there still is federal constitutional right, but it feels risky. I mean, that was already the position that folks were in when it came to strategic thinking around abortion litigation. And even the Dobbs case is an interesting example. I mean, the pro-choice folks only have but so much control over what case gets to the Supreme Court. So Mississippi passed this 15-week ban, and it was challenged when the makeup of the Supreme Court was different. And they won in the lower courts, the challenger, the clinic that was challenging the law. And then the state, the sort of anti-choice side, appealed to the Supreme Court and initially just asked, is a 15-week ban constitutional? They said initially, we're not asking you to consider overturning Roe. The question is just, can we lower this viability limit on when you can absolutely ban abortion down to 15 weeks? The state brought that question to the Supreme Court, and then unfortunately we had a justice die, and we had her replaced by someone with a different ideologic view. And then suddenly the state turned around and said, actually, no, we are asking you to overturn Roe. Because they had the votes now, they thought, and then they succeeded. So it's not just what do we want to do affirmatively, but we also have to be thinking in that defensive posture as well of like, the other side also has its opportunities to bring things into the court. Yeah, I think all of these things are all going to be important strategic considerations.
Other questions in the room? Then one on chat. You mentioned the impact the Dobbs decision could have on other cases like gay marriage, etc. Can you go more into that, and how worried should we be about those cases being overturned? How much of those decisions are based on privacy and how much based on equality?
So the question of how worried we should be is kind of up in the air. As we talked about with contraception, gay marriage, I think if there was a case that, and I mean, I don't know if you guys agree, but I think it would be very unpopular. Like as a country, it's not a popular opinion that same-sex marriage should be banned. And so that's like another politically, I think, unsound issue that would come up. But yeah, it's difficult to say. It's difficult to say with each one. But so like for Loving v. Virginia, for example, which overturned a law that banned interracial marriage, that was based on the due process clause of the 14th Amendment. Lawrence v. Texas was also, which one was? Lawrence v. Texas.
It's about same-sex relationships.
Yes.
Basically about having sex.
Yeah, so the due process clause of the 14th Amendment is very much the, you know, the fundamental pillar that has upheld these rights over time. And so it has chipped away at the protections that we have in the past. Past precedent has affirmed that these are fundamental rights. So, you know, I mean, like Justice Thomas welcomes overturning a lot of landmark cases. No one else explicitly agreed with him on that in concurrence, but I think, yeah, it's difficult to say how worried we should be or what could come first, but it all depends on, you know, what states, what laws they try to pass, and then challenges that could make their way to the Supreme Court.
I think the question also asked an interesting question about the privacy versus the equality elements of those decisions. And if I'm remembering Justice Kennedy's opinions correctly in Lawrence and Obergefell, it kind of blurs the lines a little bit about whether this is about like privacy and liberty or whether this is about discrimination against LGBTQ people. So that might leave some room to argue, but also because those cases don't come out and say, like, as explicitly as we probably would want them to, like, it is unconstitutional to discriminate against LGBTQ people, and that gets the level of scrutiny that we give to discrimination against other protected groups like women, which is intermediate scrutiny, or based on race, which is strict scrutiny. Those cases are not as on a strong footing. And actually in the Dobbs case, the court did kind of take a slight detour into the question of whether a constitutional right to abortion could be found in, could be based on protections against discrimination against women. And it basically said, based on this case from the 70s, which is like a truly horrendously reasoned case, that discrimination against abortion is not discrimination against women. And they just like left it there because they were like, we said that once, we're just going to stick to it. We're not going to revisit the idea that like this is something that disproportionately impacts women and therefore is sex discrimination. Right. But so the question of whether right to abortion could be regrounded as a sex discrimination issue did come up in Dobbs and was kind of just summarily dismissed. So I think the person asking the question raises an interesting question of whether we can reframe some of these other cases as more about equality than privacy or liberty, but I don't know where it's going to land.
Right, right. To the extent that those were like to some degree propped up by both the due process clause and the equal protection clause, we may safely say that they are at least on much shakier ground without one of those legs.
Yes, agreed.
Could the abortion debate be reframed as an issue of protection under religion, like Jewish faith gives women autonomy of their own body over preference for the unborn child because it's the women's right to their own life first, or like the Church of Satan has clearly stated that like women's bodily autonomy comes before an unborn, undeveloped life. Like, could we reframe the abortion debate in a way like that?
People are trying to. There's been lawsuits filed by a synagogue in Florida about their new 15-week ban. The Satanist Church has filed in a couple of states challenging things like waiting periods. Satanists have not gotten very far with their cases. I mean, I think it boils down to the reality that there is only one religion that the courts generally like to protect in this country, and that is Christianity. Right. So while I think while it's an intellectually sound argument, practically speaking, I don't see it getting very far. I don't know what you guys think.
Yeah, I mean, in addition to those things, which I think are all spot on, it's also that the relief in cases like that are going to be kind of limited because the way that the court has been treating the establishment clause is basically like it doesn't exist. So you can't say I challenge this law because it is, you know, it's like the state establishing a state religion, so the law is going to get cracked down. It would be the other part of religious
Free exercise.
Yes, the free exercise. So they basically the relief would be you as an individual can go to the synagogue to get an abortion, which is fraught and is not going to necessarily
Right,
be the
like
kind of-
only Satanists have these rights.
right, exactly. Or like even just like you, an individual person with this specific belief can do this. So like, again, I think we're in a tricky place with the court and also with the relief that we could get on the ground for that.
And Emily Worth touched on this, but I think it's really an example of how much Christianity is the religion that is supported by the country's well, jurisprudence right now, but there are religious hospitals, and I think it's something like 1 in 6 hospital beds in the US is owned by a Catholic church. And those religiously affiliated churches, which are predominantly Catholic, operate under religious directives that specifically prohibit certain care such as abortion, tubal ligation, for infertility treatment. And so even if a doctor at a Catholic hospital has no issue with providing this care, they cannot because of these religious directives, which, you know, when I first learned about religious directives in law school, I was just dumbfounded because I could not wrap my head around how religion could trump evidence-based, you know, care like medicine. It just blew my mind, and it still does. So, and another really problematic aspect of that is when Catholic hospitals merge with secular hospitals, those, by and large, the patients of the secular hospital are not even told about the merger, or if they are told about the merger, they aren't aware that that secular hospital will now operate under those religious directives. And a lot of these hospitals strategically have names that aren't overtly, you know, Christian. So instead of St. Margaret's, it could be, I don't know, blah, 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 but it could, like many are not, you know, explicitly, it's not clear that they are religious organizations or hospitals. And so in a lot of areas geographically, folks only have access to Catholic affiliated hospitals, which presents a huge problem because especially for you know, certain folks, they don't have the means to travel farther to a secular hospital, or their insurance doesn't, it's out of network for them. So it just creates so many barriers, and it just shows like how much Christianity is what's, you know, being I don't even know how to say it, promoted and upheld rather than freedom of religion. It's Christianity being weaponized against folks. Yeah.
This may be the last question for today, but what's your sense on who leaked the draft opinion? What was its impact? Why didn't people in power do more or prepare for it?
I mean, I will tell you my opinion. It is 100% a personal guess. I think Justice Alito leaked the draft opinion.
Really?
Yeah, because I think that maybe Kavanaugh was wavering a little bit, and he wanted to get him on the record as having voted that way and like shut down any waivers. That is a theory. I don't even quote me on it. It's so undeveloped.
But like also I as an individual also believe that.
Prescribe to that.
Right, or
personal
either
theory.
Alito or like another conservative on the bench or clerk. Yeah.
And probably I'm wrong, to be totally honest, but In terms of why did folks in power not see this coming and respond to it? Some did and some did. I mean, what Emily described in terms of the laws that we have been getting passed here in Illinois for the last half decade or so, we were doing that precisely because we saw this coming. And Illinois laws on the books around abortion access used to be horrible. We had a trigger law that said abortion would be illegal if Roe was overturned. We had trap laws on the books that were not being enforced because of Roe, but if Roe went away, they could be enforced. We had waiting periods on the books. We had spousal consent on the books. So we did, you know, the Illinois General Assembly did try to get its act together. But not everyone did, you know, and so I think there was just a certain amount of, I mean, even when we were trying to get these things passed in Illinois, we were getting a lot of pushback, like things are fine, access is okay in Illinois right now. Why do we need to take this hard vote on an issue that is seen as controversial when right now we have access in Illinois? And say because in 2 to 3 years we might not. And we were able to overcome that hesitancy, but that hesitancy was very, very real and very substantial.
And like, you know, I think was it at that point that they made another run at passing the Women's Health Protection Act and it just didn't work again? I don't remember how many times that's happened now, but like people didn't take it seriously. Like people were in denial about what it meant or that would be the actual opinion. People thought that Roberts was going to come through and wrangle some people into okaying a 15-week ban without just throwing the baby out with the bathwater, as it were. But they were wrong and it did happen. So it's, you know, it's hard at this point to like point fingers, but I do think that Alito leaked it.
That's not an ACLU of Illinois
No,
opinion.
this is just we Emily's opining.
Any final thoughts? Anything to share?
No, this has been a bummer. but
I know this has
stay
been,
engaged.
yes. And it's really helpful to just focus on the victories like Kansas, parental notice being repealed. So yeah, just focus on the victories and stay engaged and we will keep fighting.
Well, thank you, Emily, and Davina for coming today and sharing with us this, you know, information and the impact of the decision. And then it's hard to believe that next session is our last educational seminar. On Tuesday, August 9th, we'll have the session on incorporating pro bono into your career. And then Thursday, August 11th, we invite you all to come to the intern and fellow end of summer reception, our alumni reception, inducting you into the Philly Alumni Network. So visit our website and sign up for both of those sessions. And thank you for being here over Zoom and in person, and see you next week. Thank you.
We come back to the office.